both the European Council and the Council of the European Union, but I'm not here as in official capacity as representing any of the institutions. The focus of my contribution today is based on one question that I've asked myself, having read the reports that have appeared in the media, which is the following. Is there really a legal case that can be made against the EU for the abuse of migrants in Libya? When I use the word migrants, I want to cover both economic migrants and people seeking or people in need of international protection. I hope you forgive me for using a shorthand for this. I will try to deal with 6 topics in very quick succession. If I don't get through to any of these topics, you are welcome to ask me questions on these topics later on. I want to say first of all something about the facts. Secondly, I want to deal with the question of attribution to the European Union. Thirdly, I want to say something about the jurisdiction of the Court of Justice. In the fourth place, I want to mention issues regarding jurisdiction, further jurisdictional issues and standing requirements before the Court of Justice. In the fifth place, I want to raise some questions regarding the substance of the alleged crimes. And then I still have a few additional questions which I will throw out and which we can possibly debate later on. Now, with regards to facts, we have heard I think an excellent contribution from Simon Mordio this morning and also from Alexandra a few minutes ago. If you were to make a legal case against the EU, what I think is needed is that you need to have reliable reports by, for instance, international courts, tribunals, international organizations, reputable NGOs, from persons or organizations with a presence on the ground, and not only reports in the media. This is not to say that the European Union's institutions deny that abuse have happened, but for a legal case, you need to have something more precise. We also need, in my view, knowledge not only of generic facts and generic accusations, the fact that abuse is happening, but also we need to have specific knowledge of the specific illegalities that are committed. Also, we need to know who is committing these illegalities. Are they state officials, are they non-state entities? And possibly we also need to know the intent of the persons who are committing the crimes. And I think it's also important to realize that it is not sufficient for a legal case to refer to facts that happened a couple of months ago, because the situation in Libya is very fluid, it's dynamic, it changes every day, so the reports need to be up to date. And also very important from my point of view as a lawyer for the institutions, I would require that we need a complete picture, not just a snapshot of what happened on this or that day. So this is something about the facts. As regards the question of attribution to the European Union, we've heard Achilles and Ramses talk about the ILC draft articles on responsibility of states and international organizations. From my perspective, the European Union has always been a bit critical about the ILC draft on responsibility of international organizations. Main point of criticism, or constructive criticism, let's say, was we have contributed when the articles were being discussed in Geneva and in New York, was that we thought that there was not enough state practice and opinion jurists to support these articles. That's not to say that this cannot develop in the future, but we thought that some of the articles were a bit, let's say, hypothetical or even esoteric as regards international organizations are concerned. Also, we thought that there was not enough attention paid to the specificity of the relationship between the international organization and its member states. Now, the criticism, I think that remains. So we take those articles with a grain of salt. They are possibly referring to how the law should develop in the future. Now, this being said, we do have quite a bit of jurisprudence from the Court of Justice on the responsibility of the European Union for breaches of European Union law, which in our system also incorporates possible breaches of international law that is binding on the European Union. We have a very interesting pending case, which is the Polisario fisheries case, which is currently before the Court of Justice. I'm sure most of you have read this. So there you can see how you can bring in principles of international law into the European Union legal system. Now, Unlike most international organizations and most famously the United Nations, the European Union does not invoke as a general rule immunity from legal process or immunity for actions or omissions of the EU institutions. Various types of actions can be brought before Union courts, national courts or the European Court of Justice. I name the most important ones, which are direct actions, actions for actions by the institutions or failure to act. We have actions for extra contractual damage, showing that the EU institutions or its servants cause damage in the performance of their duties. Ramses mentioned this. We also have, we should not forget, the possibility of the European Commission or for member states to bring infringement proceedings. And then, of course, national courts can always refer questions of European Union law that also incorporates international law to the Court of Justice. Now, Achilles mentioned that there is quite a bit of jurisprudence on the responsibility of the European Union as a legal person. And I think he's right. I have looked at just a few cases in preparation for this conference, and I want to mention these cases for persons who like to take note. I do not have time to discuss these cases in detail, but I would invite you to look at these cases. We have a very old case, case C 72/1990, Asia Motor France versus Commission, where companies brought a direct action against the European Commission on the grounds that the latter failed to bring infringement proceedings against France, who, according to the applicant companies, had entered into an illegal trade agreement with Japan. The court dismissed this case. We have an equally sort of dated case, but still relevant, case T 220 of 1996, EVO versus Council and Commission, where an applicant sought compensation for damage resulting of council regulations that imposed a trade embargo against Iraq and Kuwait. The applicant tried to make the court state that the European Union was actually responsible for the losses suffered by the company due to the trade embargo. The case was dismissed. Another interesting case is case T201 of 1999, Royal Olympic Airways versus Council and Commission, where a Greek travel company claimed that the European Union had supported the illegal NATO military intervention in Kosovo during the former Yugoslav war. The court dismissed that case. A more recent case, it was also a very relevant case, is case T 292 of 2009, brought by a person called Mughrabi versus the EU institutions. Mughrabi claimed that he had reports from the UN stating that his rights as a Lebanese citizen had been violated, his human rights had been breached by Lebanon, and Mr. Mughrabi. 2 minutes left. Mr. Mughrabi claimed that the European Union should have suspended the association agreement which the European Union had with Lebanon. The case was dismissed. And then the last possible case I'm going to mention, the last case that I can mention in the time available to me is case T73 of 2003, Zawi versus Commission, where relatives of a person killed by the military wing of Hamas claimed that the European Union was funding the Palestinian authorities and that some of this money went to education of Palestinian terrorists. And the applicants claimed that the European Union must have known that the fact that in the education system in Palestine it was taught that Israelis should be targeted. The case was dismissed now. All these cases lead me to making a few statements, perhaps not nuanced enough, but what these show is that, for instance, it is not sufficient to show that an EU member state has committed a certain act or has failed to act. The general rule is that the European Union carries no legal responsibility for actions or omissions of its member states. Also, the EU cannot be held responsible for a breach of EU or international law by a member state, even if the European Commission failed to bring an infringement proceeding against that member state. In a similar vein, the European Union cannot be answerable for actions of third states or international organizations, even if these actions are allegedly the consequence of actions taken by the European Union in the first place. A fourth point that I derive from this case law is that the European Union is not legally responsible for breaches of international law by a third state, even where the European Union could decide to take treaty action in respect of that third state, but elects not to do so. And finally, the European Union is not responsible for terrorist acts by non-state entities merely because these non-state entities receive funds from the European Union. I'm running out of time, but I just wanted to make one point. A major hurdle when you try to bring an action before the Court of Justice is the fact that the Court of Justice is in principle not competent to deal with CFSP actions. So we're thinking about making a legal case before the Court of Justice for what is happening in the Central Mediterranean. As Alexandra mentioned, there are CFSP and non-CFSP actions. In principle, there is no responsibility, no competence of the Court of Justice. We do have cases where the European Court of Justice has tried to narrow down this exception for CFSP actions, and as Ramses mentioned, we have a few cases relating to contractual issues, regarding staffing issues, etc. But in principle, that is a major block. So for those type of actions, you're left with the possibility of bringing legal action before a national court of member state. But when the case is being transferred to the European Court of Justice by way of preliminary reference, you will still have the problem with lack of jurisdiction of the Court of Justice for CFSP actions. I need to stop here, but of course we can discuss some of the other subjects which I have been able to broach in my opening statement. Thank you very much for your attention.